pending this investigation, and in the event of such disinclinment, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent in custody. Benigni, we submit, Your Honor.
Okay. Your Honor, I was thinking that the conditions that was going to say something. But let me start with if whatever wants to add, you can add. But your last one, yes. Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean to the respondent in this matter. Please grant it. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably today. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyamo case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Shapatia mingi mbonazi mpaka tumechoka, sio? What does the court say something to do with compelling reason? And this is the Court of Appeal division in the realm of the Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once you have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to his phones. What they did not tell you is that he gave them the passwords and they are keeping quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the window. Let's finish that one. It's a simple thing, a 1-minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit, and what he has said here on oath, is that, in fact, I've given him a password. Take a password. It's not about the password. Give the court. It's not about the password. They're telling you.
So we don't have to break it, eh?
Yes, Your Honor. The issue is not about the SIM or the password. It requires a lot of things.
No. Your part is crucial. I'm running the show.
Okay.
Now, they are telling you about witnesses. They are not telling you the affidavit which witnesses, but they are telling you something else that is imaginary, that they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the Gigiri police station, headquarters CIT, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the litigation. Then have they convinced you, Your Honor? And I am saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say pre-bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why you have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state.